topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Tampa. Welcome to another Ask the Expert show, where we bring you the finest experts in the field of legal, health, financial, and home improvement. This weekend, I was looking at our YouTube shows. We have done 1,600 shows. And the only reason why, and there's actually more, that's just when we actually started on YouTube, but the only reason why I'm bringing it up now is the show this morning, our estate planning show that we do the last Monday of every month at 9 p.m. Eastern time is my favorite show. Every month I look forward to this show. And when you meet, if you've never listened to this show and you meet our great expert attorney, Debbie Baker, you'll see why I say that. Good morning, Debbie.
9 a.m., not 9 p.m. But anyway, so I just want to give YouTube an acknowledgement for a podcast. I had a friend text me on Saturday who lives in Maryland. She said, "Your voice is in my house." And I went, "Huh?" And she said, her husband was watching a podcast and you were talking. And she said, it was amazing. So thank you, YouTube. I mean, I thought that was just quite wonderful. I didn't know what month.
I got to tell you, Debbie, we get a lot of emails from viewers that tell us how much they appreciate your show.
That's great,
Debbie,
right?
Because we're getting so many new people every month. Tell people about your firm and about yourself. Okay,
and then we're going to talk about beneficiaries. So my firm. I've been in practice now I've been a lawyer for almost 11 years. I went to law school as a walk of faith. Had thought about it when I was younger and always had great reasons not to go. Great reasons not to go. And then when it was the right time, God said, go to law school. And then it was like, oh, okay. So I went to law school. And I'd been an executive coach for over 30 years before that in the world of the commitment is that people have the lives they say they want. And how did I help them get it out of their own way, which was a glorious practice. At law school, I do estate planning because it's just a great way to be of service. People don't do it for lots of reasons. They don't do it because they don't think they have anything. They don't do it because they don't think they can afford it. They don't do it because they're convinced they're going to die as soon as they do, which, interesting enough, does happen, but at least it's been done. And they want their families to take care of it. So being an older student was glorious because I wasn't there for anything but to learn and have fun. And I wasn't there for law review or internships or clerkships. And the practice is absolutely driven by my need and my desire to be of service. So I talk to anybody who calls me, whether they call me from in-state or out of state. I'm only licensed in Florida, but I can help people ask intelligent questions of somebody they're going to see, just based upon what I've learned in Florida. All laws are not the same, but generally they're pretty close. Except in Louisiana, which operates on a whole different thing, which Rebel well knows. But it's glorious. So when things work, it actually, brings me to tears sometimes, because all I'm doing is sharing something I've learned and with people who have no reason to know. And it's a gift beyond measure. So I'm always grateful to God for sending me. I'm always grateful that I didn't miss the prompt and I didn't avoid it. Um, so yeah, and again, estate planning, probate, elder law, they're all about helping families in need at the moment or in possible need in the future, with the idea of mitigating some of the angst and the horror, waiting too long and then being stuck in awful positions. So, so thanks for asking. We haven't done that for a while.
Yes.
Yeah. But I want to talk. Go ahead.
It's a very incredible story.
Oh, well, thank you. I lived it, so it doesn't seem quite as incredible, and I'm always honored and humbled when people find it incredible. But that's okay. That's really okay. So we can talk about beneficiaries because this has really come up a lot. Okay. And and you always have great questions, Steve. So you're welcome to interrupt me anytime with a question. Interrupting is one of my ground rules. For anybody out there who's not an interrupter, it's really, it's hard. You never get a word in edgewise, and the people you're talking to always know what you're going to say. But anyway, so here's what I've learned about beneficiary designations over the last 11 years. They are essential. They are an essential foundational piece of any plan you have. And what happens is they often get overlooked. I've run into people who have accounts at banks, and the bank never asked the customer who they wanted to name as a beneficiary. They left it for the customer to bring up. And I've got a probate like that right now. It's not a lot of money, but whatever, because the bank didn't think it was their job to ask. So what is a beneficiary designation? It's a written instruction you give some financial institution to tell them what you want to happen to your assets when you pass away. So that's banks, 401ks, IRAs, stocks, anything that you own that could be liquidated, and you have not told somebody whom you have not told the institution who you want to get that after you pass. Problem is that when you don't do that, even if the only beneficiary by law is a spouse, that spouse still has to go to court to get the right to get that asset. And that's money that could have been not spent. I've said here many times, when somebody passes, the only thing you should have to do is grieve. So people think about doing estate planning. Hopefully most of you listening or watching have yours in place. Please, if you don't, just do it. Just do it. They think about wills and trusts. Beneficiary designations override a will. So if your will says, my children, Susan and David, split everything 50-50, that's great. The court will do that, but only after Susan and or David go to court to get the right for the financial institutions to do that.
Oh, I didn't know that.
Oh, yeah. So if you tell a financial institution that your beneficiaries are Susan and David, the will could say my money goes to Joe and Sally, and Susan and David would get the money because the beneficiary designation overrides your will. So you want to be really careful, and you really want to set them up. They override a will. I gather they'll sometimes override a trust. I've not had that happen to me, but I'm saying it's not possible. And the mistakes happen because, or people name minor children. Susan and David are minors, like they're 6 when somebody names them a beneficiary, and the parents die before they reach the age of 18. And then what happens is a guardian has to be appointed to manage that money because children under the age of 18 can't inherit money. And people don't know that. So oftentimes you're working for somebody and they have a 401k plan. So you invest, you say, take 3% of my money every week or whatever it is, every paycheck, but nobody asks you about a beneficiary. Or you set up a bank account, like I said, and they don't ask you and you don't think to know. Annuities and pensions are the same thing. I've had more than one probate because somebody was a beneficiary of a pension and didn't name a contingent beneficiary. So the person who had the pension died, the beneficiary died, and there was nobody in the next level down to collect the pension. And it took 15 months, maybe longer, to get it settled, to get the estate settled. And it wasn't a lot of money, and it could have all been avoided. So the beneficiary designation is the written instruction, and how the problem pays out. I haven't had this happen, but I know it happens. So a couple is married and they are named beneficiaries on each other's life insurance policy, and they mistakenly believe that the divorce makes null and void that designation. Well, it doesn't. So both parties remarry and think, of course, now my current spouse will be the beneficiary of that life insurance, and they are wrong. So what happens is the spouse passes, the former spouse shows up with a death certificate, and they get all that money.
Wow.
Because that's what the law says. So people will forget to change those beneficiary designations. And it's not done malevolently. It's done ignorant. It's done out of ignorance. So they're just. I'm looking for the examples that I've learned here. If you don't do it, you want to review your beneficiary designations on a regular basis. So I've come to believe that if you've appointed spouses as primary beneficiaries and you've appointed children as contingent beneficiaries, but you don't want those children to inherit until they're a certain age, then you might want to do a trust and make the trust the contingent beneficiary. So you've got something in place where money can be funneled. I love using my hands for all those people who are listening. So I love, so the idea that money gets funneled at your direction to an entity that somebody else administers so that the way you want your assets distributed gets done. And since somebody can inherit at 18 and you wouldn't have wanted those children to get anything until they were 22, if you die between 18 and 22, they get that money and it wouldn't be what you wanted. So,
wow.
Yeah. And there's no reason in the world that anybody knows this unless they talk to somebody who works with it. So, if there's anybody listening who thinks, well, how come I didn't know that? Or how come somebody didn't tell me? I can't say why somebody might not have told you, like a financial person or an attorney, but why you didn't know it. You know what you know about whatever it is you do. There's no reason for you to know about something else. So anyway, I've talked enough. We're almost 15 minutes into my 25.
No. You're fine. So just having a simple will is not enough. If you've got assets.
Having a simple will does not avoid court necessarily. It just doesn't. You can't say my house goes to Susan and David equally in a will, because they have to go to court to get the right to own the home equally. can't say they get my money equally without going to court unless you made some kind of beneficiary. Having a will with just those stipulations in place is better than having nothing, because if you have nothing, okay, and Susan and David have siblings that you would have disinherited, then Susan and David are now obligated by law to split whatever is in that estate with those siblings that their parents would have given nothing to. So the will is better than nothing, because the state, where the state you're in, or Commonwealth or whatever, they have a plan, and the plan is intestacy, and money gets distributed by law. So the one probate I have now, wife died, bank didn't talk to her about a beneficiary, didn't name one. She's got a daughter from a previous relationship, and by law, because there's no will, that daughter, who was estranged from her mother, has a right to 50% of the estate. I mean, it's the law. There's not any. I mean, the dad, the husband, is disappointed, but he appreciates that it's the law. Had his wife named a beneficiary, or even had a will that said, "My husband, Steve-O, gets everything," we wouldn't have had. Might have had to notify that daughter, but she wouldn't have a right. So, a basic will is much better than nothing. The beneficiary designations are essential, and they often get overlooked, or they don't get updated, and it's really important that they get updated. Child gets disabled. They can't inherit money. You need to do something else, because if they're getting government benefits and they inherit money, then you're in this race against time to keep them from being thrown off government benefits until you get rid of their assets. Lots of reasons, none of which I knew 11 years ago. None of which, in terms of the importance. So it's really...
Yeah, I thought about you this weekend. There was a NFL football player, 27 years old, made a lot of money, and he committed suicide this weekend. Now, there's no way you could ever have planned for something like this, but could you?
If he had documents in place, he could. Life insurance will ask for what they call a longer form death certificate, which will list a cause of death. In the olden days, when my father was really young, because he had attempted suicide, there were like lifelong exclusions about suicide. Okay. Now I think there may be 12 or 24 months. If within a certain period of time while the policy issues, somebody takes their own life, I think, I don't know this, I think the policy can be voided. So they ask for long form death certificates so that have a cause of death. But a will and beneficiary designations, not for life insurance, if there's that exclusion, would have stood up, regardless of whether somebody took their own life. Too many people are taking their lives. It's just, oh my God.
Oh, I know. I know.
And hopefully, because I had my first financial planner, one of his areas that he loved was working with athletes. This was long enough ago that they weren't getting quadrillions of dollars, but they were getting substantial bonuses, working with them right after they signed so he could protect their money, because he'd experienced secondhand young men or women, probably more young men then, but young men who'd gotten even whatever, a few $100,000 or $1 million, and they squandered it because nobody was there to say, no, you have to protect it.
I got it, Debbie. I've got to ask this question. I think about it every show, and I finally decided to ask you.
Okay.
This is very strange question.
Okay.
We had an estate planning attorney here in South Florida who did a show with me for 8 years. We had a great relationship. He even brought his son on a couple of shows who did personal injury. But he did, this is the whole key to this story. He did estate planning. Well, I don't know if you heard about it last year, but his son murdered him. That's not what I'm asking.
Okay.
I'm asking is the wife said that her son had been stealing money from her. She was a beneficiary on the life insurance. How was he able to get away with that?
I have no idea. The thing that came to my mind, and I don't know, is if he had his father's power of attorney or his mother's power of attorney.
Oh, maybe that was it.
Oh, that's. I mean, I have no idea how he got away with it. In the world of online stuff, I mean, if somebody, you really, powers of attorney, you really have to trust the person. If somebody had access to your online stuff, who knows what you could do? You could make withdrawals, certainly, without any proof that you have the right to do that necessarily. Because if I know your password and I can get into your policy or your bank account, they don't know that it's not you or that it's your agent. They just know that somebody's taken money out of your account. I have no idea.
Well, the only reason I brought, because he's an estate planning attorney, and you would think that he had all of his bases covered. I'm sure he didn't plan on his son murdering him.
No,
but,
but you say the wife said that the son stole from the life insurance, so that's a whole different. I mean, I have no idea how that would happen.
yes.
Wow.
So my next question is how do you choose who, when it comes to beneficiaries and there's children involved?
Yeah.
How do you choose? Do you have guidelines as to how you divvy up the money, or is it just something simple? Everybody gets,
You have to say, my guideline is you don't appoint one with your thinking that they'll distribute to everybody. So if you've got 3 or even 2, you distribute equally. You don't have to distribute equally. You can give different percentages, but for the sake of, you distribute equally. So one of them shows up with a death certificate and the bank writes the checks to all 3. As soon as you appoint just one, and the one is not happy with the others for how they treated you while you were dying, or they've always disliked the others and they think it's about time you got your comeuppance, they have no legal obligation to distribute that money. It's all theirs by law.
Hey, Debbie, I'm so sorry.
I know we're out.
Your show goes by so fast. Tell people real quick how they can reach you.
So you can find me at Deb Baker, 2 B's, Deb Baker at London Baker Law, London like the city, londonbakerlaw.com, 813-586-1332, 813-586-1332.
Thank you so much, Debbie. Have a wonderful rest of the week. We'll see you next week. She's on with us last Monday at 9 p.m. Eastern time. God bless you, Debbie.
You too, kiddo. Thanks, Rebel. Bye.
And that's, we're going to go to a break. We'll be right back.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.